And the recorded session would be uploaded on our YouTube channel as well, which is Jazz Real Estate Eview Group. And if you would like to go back and view this webinar, you're more than welcome to have a look as well. Once again, if you can please either in the chat box or please just put a thumbs up that you can hear me loud and clear. That would be amazing. I have my chat box open as well. Towards the end, you can please keep putting your questions as well. Towards the end, we'll do a quick Q&A, and if you have any questions, I'm more than happy to answer as well. So guys, let's kick start from the perspective of notice of intention to sell. If you are a rental provider owning a rental property and you have tenants living, or renters, what we call them now in Victoria, the renters are living in the property, the law requires a rental provider and their agent to must issue a notice of intention to sell, which is minimum 14 days before you could even start the open homes or show prospective buyers the property. Now, let's say, for an example, you issue a notice of intention to sell for 14 days. You have a discussion with your selling agent. You decide to sell. Your property management agency must issue a prescribed form, which is available on Consumer Affairs website, also on Vacate as well, on Vacate Hub, which is used by the agency. So we use that instead of Consumer Affairs forms. But then prescribed forms can be different in terms of how they look, but the content is exactly the same. So 14 days intention to sell. Let's perspective. 1st of August, you're sending a notice of intention to sell, which lapses on 14th of the August. Now, you cannot start the open home on the 15th day because there's a bit of a twist in the legislation. It's a common understanding that, okay, you have to send 14 days notice of intention to sell and you can start the open home straight after. That's not the case. The law requires Section 86.2 under the Estate Agent and the Residential Tenancies Act is also aligned with notice of intention to sell, which is that you can only gain access to the property once the 14 days is finished, and then you propose an inspection time. So it doesn't allow a rental provider to start the inspections on the 15th day, which is a common understanding in the industry because the Section 86.2 is not generally discussed during the discussions with estate agencies, and most of the agencies are not aware about that as well. And there are a lot of other things in the acts that a lot of the agencies are not trained because, again, the government's not taking initiative to train property managers. They expect everything to be known. So hence why our agency has hired external solicitors to get a lot of training around the acts and legislation. So we get to sort of see a lot of ins and outs of the nitty-gritties of the sections and subsections of the acts, which can be aligned with a main section or the act of the RTA. Coming back to the inspections. Now, let's say 14 days have finished. You must give a tenant notice of intention of entry notice, which we call. Now, that's the right way of doing it. Yes, if there's a mutual understanding with the renter via email, great, good enough. However, if a renter is smart, they know their rights, they could backfire in the future as well. Number one, you issue an entry notice, which will give you at least required 3 days time for you before you can even access the property. Now, you cannot send a notice of entry via email. That's the only notice under the Estate Agent Rental Tenancies Act that you cannot send via email. Other notices, if the tenant has agreed for electronic communication, you can send the notices or any breach via email or registered post or normal post, or you can serve it in person. Notice of entry, you can do it in 3 ways: ordinary mail, in person, or registered post. The risk with the ordinary mail is the tenants can say, well, we've never received a notice. That's a challenge. So in person, much better, but then it's again sometimes harder to prove that it was served unless you record the tenant while serving it, which is a bit awkward as well, unless, of course, there is, let's say, some friction and you want to be safe and you want to record for your safety as well. As a property manager, you should record while you're serving the notice. And going off track, which is an important one, if you're getting your properties managed and your agent said that they went to the property to serve a notice of entry or any other notice, and the tenants refuse to take it, they refuse to be served, you do not have to walk away from there. As long as the property manager has got the phone camera on and you are in a public place, which is entry door outside the property's premises, and if you put the notice on the tenant's feet and it's touching their body, the notice has been served. So that's absolutely legal to serve a notice of entry or any other notice. Coming back to intention to sell. Now, that's how the notice of intention to sell is issued. One more fact about notice of intention to sell is there's no end or lapse date. Let's say you've put the property on the market for sale. You've served the notice of entry. You want to sell the property with the tenants in there. You've started the marketing. Your property's on the market. You've started the open homes. Your tenant is not keeping the property well. During the open home, your agent turns around and say it's better to sell the property without tenants. You can no longer issue a notice to vacate under 91ZZB Section 1. That can ideally be done before you started the campaign. So ideally, because you've gone that stage where you've told the tenants that you want, because 91ZZB notice of intention to vacate or notice to vacate is about tenants vacating and then the rental provider wanting to sell the property as soon as the property is vacated and or the lease is terminated. So you'll have to wait until that time if you were to sell the property with the termination of the tenancy or vacant possession. But in this instance where you decided to sell the property with the tenants, you have started the campaign, you no longer can issue 91ZZB subsection 1. You then have to wait for the property to sell and issue 91ZZB Section 3 or Section 2, which is you've entered into an unconditional contract with your purchaser now, and one of the condition is that you and your purchaser requires a vacant possession and you want to serve a 90 days notice. Now, guys, 90 days notice has been changed down from 60 days. So it used to be 60 days notice to vacate until November 2025. Now you must provide a 90 days notice to the tenants. And if, let's say, your lease is finishing in February 2027 and you give 90 days notice now, and you've put a 90 days, let's say, finishing in November, that notice is invalid. Even if you're issuing a 90 days notice to vacate and your lease is expiring in Feb 27, your last day of vacate, or you want the tenants to or renters to vacate, should not be before that last day of the tenancy in 2027's Feb. So if there's any confusion, please do put it in chat. I'm more than happy to clarify as well. Coming back to notice to vacate. Let's say, for an example, your property's on the market, and this is going to be a situation right now, especially where the market has changed, where a lot of the landlords are currently seeing influx of listings in the market. You'll have tenants living in the property, which might give you a bit more cushioning as well, because interest rates are quite high. You're paying a lot of mortgage as well. Most of us are at the moment. And especially the ones who've purchased the properties in the last 2 to 3 or 4 years, they're paying heavy mortgages right now. So they may not want a property to sell without tenants because they got some money coming in. At least they're not under pressure, because a lot of people have, let's say, multiple properties, or they currently own the property where they're living. And this is a rental property. They're paying high mortgage here, high mortgage there. If a tenant vacates, then they're paying double mortgages. Let's say some clients, some vendors, they're paying all their salaries towards mortgages. And until the rental property sells, they are not freed up with the cash flow. So many of the landlords we're seeing at the moment trying to sell with the tenants, but then they're facing problems where the tenants are not presenting the house well, either they're taking a hit on the sale price, or they're deciding to either then issue a notice to vacate to the tenants upon the estate agents advise that they should stage the property, maybe paint the property as well. So there's a lot of things going on. So this situation would certainly be helpful, or this information would be helpful, I should say. Let's say the tenants are living in the property and they say, no, you've not given me 91ZZB, you're giving it to me now. Now the campaign's up and running. This notice is invalid. You may find yourself in a situation that your 90 days notice is issued. Let's say the tenancy is month to month, 90 days notice issued. Last day comes up in November. The tenant is still in the property. They haven't vacated. Agencies decided to sort of realize that at the end, The tenants have not vacated because they did not follow up before, which is another problem. We can discuss that later. The tenant turned around and say, well, your notice is invalid, Mr. or Mrs. Agent, because this notice was not served. It's contrary to the law. And if, let's say, you go to possession hearing to tribunal or magistrate's court, magistrate may find the same, or tribunal might find the same, that your notice is invalid. Your case might be struck out, and then you may have to do two things. Or before going to tribunal, you either retract the ad from the internet. There's two ways to do that. You can either withdraw the ad completely, which obviously costs you more money if you relist, or you pause the ad for, let's say, a period of 3 to 4 weeks or some period of time. Or let's say not 3 to 4 weeks, I should say 90 days. Because you've now paused the ad, you send an email to the tenant that we've officially ended the sales campaign. That way you can then give it a rest, send another notice to Vacate, which is 91ZZB, that rental provider now wishes to relaunch the property again and sell the property without the tenancy, which means your one campaign must stop. Give it some time, issue notice to vacate for 90 days. That means you cannot relaunch the property for the 90 days period. Some landlords would question that, can I just launch my property online now without doing open homes? At least my property is being seen by buyers. We can only do private inspections, not do open homes. That might be helpful. No, it's not. It's still contrary to the law, because you are officially running a sales campaign while the tenancy and the tenants are living in the property. It's very critical for the rental providers to know. One more question about notice of intention to sell. When the legislation was written about notice of intention to sell, there's no retraction or end date to it by law. So the moment you issue notice of intention to sell, even though you don't want your tenants to vacate the property, the tenants can still give you 14 days intention to vacate, even though they've got another 9 months left in the lease. You cannot charge them a letting or lease break fee, letting fee, marketing, or rent up until certain period of time, because your intention is not to relet the property. You've issued a notice of intention to sell for 14 days before you can access the property for inspections. The tenant can then serve you a counter notice of 14 days. They do not have to complete their lease. They do not have to give you 24 weeks, which is 28 days notice as well. Let's say another issue or another situation. You've not given notice of intention to sell. The tenancy is month to month. The tenants want to leave the property or renter. They must give you 28 days notice before they can vacate the property. In this situation, you've served a notice of intention to sell, but you've not asked them to vacate. They can still vacate by serving you 14 days notice. So, and then let's say, for an example, you have the tenants living in the property and you were trying to sell the property and you could not get the price you want, or for some reason you want to retract the sale. Let's say you've withdrawn the property from the internet and the tenancy is still for another, let's say you renewed the lease. You say, tenants, I'm going to give you another 12 months lease. Let's say the lease starts in October up until next October 2027. Renters decide to buy their own property in Jan 2027. They can still issue you a 14 days notice, and you cannot still charge them letting fee or lease break fee, because back in 2026 you've issued a notice of intention to sell, and the law forgot, in my opinion, and all the solicitors have advised us, the law forgot to put an end date to that notice of intention to sell. So it does not end with the sales campaign ending, even though the tenancy is still continuing. So bear in mind, they can still give you a notice of intention to vacate 14 days, even 2 years after, because you've served a notice of intention to sell maybe 2 years, 1 year, 6 months before. So that's one. Let's come back to the last part of the series today, which is the endangerment and intimidation by the tenants. Some of the times, the bar is quite set high by the legislation. If, let's say, for an example, a tenant says, in this situation, I've received a lot of phone calls from other agencies as well, because they've been threatened by a tenant verbally. However, that did not give them grounds to issue a notice of vacate, which is immediate vacate. But if you prove that the endangerment is number one, valid, ongoing, the threat and the risk is valid and existing, and then either rental agent or its agency, rental provider or its family member, immediate neighbor are in danger, you can issue an immediate termination of the lease. If the tenant fails to vacate, you can apply for a hearing for possession. Now, in this situation, the tribunal generally opens up a hearing very fast. It could potentially go directly to VCAT rather than RDRV. RDRV listens to the cases before it's become a body right in the middle before the case goes to VCAT. They're trying to ease the workload and the case loads for VCAT as well. In this situation, the tribunal must and ideally should hear the case and the matter much faster than any other matter. However, to prove and seek possession, you need to satisfy number one, section 330A, which is reasonable and proportionate, that is trivial, and it is reasonable and proportionate for someone because law treat possession as making someone homeless. You need to prove that. You need to have all the points, point A to point J, in section 330A, plus a lot of documentation to ensure endangerment is number one, valid, and it is actually a real threat. Your statements, stat decks, any valid footage, so long it's not breach of privacy. Number three, you must provide any statements from the neighbors. If there's any ongoing issues, it's always best to keep recording the statements or emails from the neighbors and keep a file of it. You can also then create a pattern of the tenancy if not current endangerment. Sometimes it's not really valid for the tribunal to give you a notice to vacate or the possession because the past issues have been now not that high, that the intensity of the endangerment is not that high. Number one, let's say for an example, you go to a property, the tenant says, if you don't do this, I will punch you in your face. It may not be considered as endangerment because the tenant can potentially argue that it was a joke. But again, if that has happened multiple times and there is a pattern of tenants saying this thing to other people as well, and you have facts for that, or there's something in writing about the tenant's behavior, then that could potentially lead. One instance of this sort of threat is not, but intention to kill, intention to harm bodily as well. Those sort of things must be recorded faster. Now, if something like that happens, it's always best by law to record all the information to be able to have the evidence preserved much faster with all the dates. If, let's say, for example, you don't know the exact times, because that's why we say make notes with the exact times. If not, you must provide on or about this time, this happened. What did you do? And then if there's a video available, you could potentially record a video if you are under threat. But again, at the same time, if you feel that you would be under threat, you always accompany another family member if you are a rental provider yourself heading to the property, and make sure that you keep distance from those kind of tenants. If you feel that is happening, you must notify your neighbors, where next door neighbors with the property, that this is happening. If they can accompany you, that way you can have more evidence as well. If it's a property management agency, there's always best to accompany a senior manager and or perhaps a colleague as well for your support and for evidence purposes as well. So if needed, the statements can be recorded. So as I said, the bar for endangerment and evidence has been set quite high. If proven, the lease can be terminated immediately as well. So guys, anything on these three topics today, please, you can put that in the comment section or perhaps ask any questions. More than happy to answer anything before we wrap up today's session. We've still got about roughly 8 minutes to go. More than happy to answer any questions. If you want to unmute yourself, more than happy for you to unmute yourself and ask any questions or put it in the chat box. No questions? Most welcome, B. Thank you so much. And we will be doing this fortnightly now, all these sessions, because there's a lot more litigious now in property management at the moment. And As I always say, guys, number one thing is to avoid all these things, you must have an agent who's got maturity, or yourself if you are self-managing your properties, that you go through a stringent checks of leasing process. I can't stress enough, because I've seen a lot of property managers, owners in problems with the current tenancy. And if you dissect everything, the problem was actually not the problem. The problem was actually at the start, that tenants would not should have never been approved for a tenancy as well, ever at all. When we do open homes, we always screen and scrutinize people's body language, their behavior, eye contact, facial expressions, how they arrive, how they talk. That tells a lot about that person. Then thorough checks, have a chat on the phone, understand a little bit more, treat it as like a job interview. You would not hire someone by just seeing a resume. I see a lot of the times property managers are approving applications after doing an open home. They come back to the office, let's say on Monday, they see an application, they see the income's fine, for an example, earning enough, husband, wife, three kids, blah, 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 everything's fine. An email goes out, congratulations, you've been approved. This is the lease start date. We'll send you lease agreement. Please put your rent and bond, keys, pickups, done. You've not built a relationship with the tenants. You don't know who they are. You don't even know whether they should be ideal people. They might look good on the paper application. They may not be the right people for you. They have to be aligned. In return, what then happens is that you bringing in the wrong people as your tenants. There's maintenance problems. They're creating a lot of issues. That's creating a workload for the property manager. Owners who are busy, they're receiving a lot of emails, phone calls about maintenance, which should not be part of the owner's responsibility, anyways. And then thereafter, it reduces the service levels towards the landlords and the service levels towards maintenance, and that just creates a whole lot of problems. And then some tenants stop paying the rent, and or perhaps you don't have sort of history about them. I'll give you an example. I've had a phone call come in from someone couple of weeks before. We are not managing their property. They saw one of our videos online about a possession we took about 2 or 3 years before, where the tenants were not vacating the property after the ceiling collapsed, and they were living there rent free. They lived there for 9 months before the rental provider reached out to us, and we got them the possession in the hearing. A lot of evidence was gathered before we could go through the hearing, and the other side, the tenants were represented by a lawyer, like a qualified lawyer versus us as an agent. The comment from the tribunal was, and it was actually in magistrates court as well, and they said both parties have prepared really well, and we did get the possession. We did win that case as well against a lawyer. It's basically because of knowing the acts and preparation of the case. Now, that case was heard by a rental provider who's got a property here in western suburbs. I won't name a suburb. I won't name anything about due to privacy. It's not too far from here. It's a few suburbs away from Point Cook. Now, the rental provider found a tenant himself on Facebook. The tenant moved in. They gave all the keys to the tenants. They didn't retain any spare keys. The tenant did not pay the rent after paying the rent and the bond for the first month, ever at all. And it was few months in. The tenants have not let the landlord in or rental provider into the property. Every time the landlord turns up, he turns the music off or on, loud music, so he doesn't hear the knock. The landlord stands outside the property, keeps knocking for half an hour. He's not getting anywhere. He's not paying the rent. And obviously, breach of privacy. Even if the tenant is not paying the rent, you cannot just rock up and use a spare key or get the locksmith in and change the lock. There's a lot of things that if you breach, you may be still in hot waters with consumer affairs or the legislation or the government as well. A lot of fines have been imposed for such conducts to the landlord. So it's a lot of it's litigious right now. So in that situation, things can be streamlined, but obviously it's like a mess that you have to create yourself and you have to clean yourself. So ideally, everything starts at the time of letting your property out. Be sure to be diligent, do your due diligence, and be careful at this time of the start. Guys, so any questions I'm happy to answer. Again, before we wrap up, it's 11:13, so we can wrap up if there's no other questions, and I'll post this video on YouTube as well. And if you have any questions, more than happy to answer after. You can send me an email or please feel free to give me a call. Always here to answer anything for you guys. Nothing. Thank you so much for your time, guys. I really appreciate your attendance. And this is me signing off. And we'll be in touch again in fortnight's time. Again, I'll send the information across for the next webinar one more time. Thank you so much. Take care.